the plaintiff himself acquired no title to freedom by being taken by his owner to Rock Island in Illinois and brought back to Missouri. This court has heretofore decided that the status or condition of a person of African descent depended on the laws of the state in which he resided. It has been settled by the decisions of the highest court in Missouri that by the laws of that state, a slave does not become entitled to his freedom where the owner takes him to reside in a state where slavery is not permitted and afterwards brings him back to Missouri. Conclusion. It follows that it is apparent upon the record that the court below erred in its judgment on the plea in abatement, and also erred in giving judgment for the defendant, when the exception shows that the plaintiff was not a citizen of the United States. And as the circuit court had no jurisdiction, either in the case stated in the plea in abatement or in the one stated in the exception, its judgment in favor of the defendant is erroneous and must be reversed. This case was brought up by writ of error from the Circuit Court of the United States for the District of Missouri. It was an action of trespass via armis instituted in the Circuit Court by Scott against Sandford. Prior to the institution of the present suit, an action was brought by Scott for his freedom in the Circuit Court of St. Louis County, State Court, where there was a verdict and judgment in his favor. On a writ of error to the Supreme Court of the state, the judgment below was reversed, and the case remanded to the Circuit Court, where it was constituted to await the decision of the case now in question. The declaration of Scott contains 3 counts: 1. That Sandford had assaulted the plaintiff; 1. That he had assaulted Harriet Scott, his wife; and 1. That he had assaulted Eliza Scott and Lizzie Scott, his children. Sandford appeared and filed the following plea: Dred Scott v. John F. A. Sandford. Plea to the jurisdiction of the court. April term, 1854, and the said John F. A. Sandford, in his own proper person, comes and says that this court ought not to have or take further cognizance of the action aforesaid, because he says that said cause of action, and each and every of them, if any such have accrued to the said Dred Scott, accrued to the said Dred Scott out of the jurisdiction of this court, and exclusively within the jurisdiction of the courts of the state of Missouri, for that, to wit, the said plaintiff, Dred Scott, is not a citizen of the state of Missouri, as alleged in his declaration, because he is a Negro of African descent. His ancestors were of pure African blood, and were brought into this country, and sold as Negro slaves, and this the said Sandford is ready to verify. Wherefore he prays judgment whether this court can, or will take farther cognizance of the action aforesaid. John F. A. Sandford. To this plea there was a demurrer in their usual form, which was argued in April, 1854, when the court gave judgment that the demurrer should be sustained. In May, 1854, the defendant, in pursuance of an agreement between counsel and with the leave of the court, pleaded in bar of the action, not guilty. That the plaintiff was a Negro slave, the lawful property of the defendant, and, as such, the defendant gently laid his hands upon him, and thereby had only restrained him, as the descendant had a right to do. That with respect to the wife and daughters of the plaintiff, in the second and third counts of the declaration mentioned, the defendant had, as to them, only acted in the same manner, and in virtue of the same legal right. In the first of these pleas, the plaintiff joined issue, and to the second and third filed replications alleging that the defendant, of his own wrong, and without the cause in his second and third pleas alleged, committed the trespasses, and etc. The counsel then filed the following agreed statement of facts, viz. In the year 1834, the plaintiff was a Negro slave belonging to Dr. Emerson, who was a surgeon in the Army of the United States. In that year, 1834, said Dr. Emerson took the plaintiff from the state of Missouri to the military post at Rock Island in the state of Illinois, and held him there as a slave until the month of April or May, 1836. At the time last mentioned, said Dr. Emerson removed the plaintiff from said military post at Rock Island to the military post at Fort Snelling, situate on the west bank of the Mississippi River, in the territory known as Upper Louisiana, acquired by the United States of France, and situated north of the latitude of 36 degrees 30 minutes north, and north of the state of Missouri. said Dr. Emerson held the plaintiff in slavery at said Fort Snelling. From said last mentioned date until the year 1838, in the year 1835, Harriet, who is named in the second count of the plaintiff's declaration, was the Negro slave of Major Taliaferro, who belonged to the Army of the United States. In that year, 1835, said Major Taliaferro took said Harriet to said Fort Snelling, a military post situated as hereinbefore stated, and kept her there as a slave until the year 1836, and then sold and delivered her as a slave at said Fort Snelling unto the said Dr. Emerson hereinbefore named. Said Dr. Emerson held said Harriet in slavery at said Fort Snelling until the year 1838. In the year 1836, the plaintiff and said Harriet at said Fort Snelling, with the consent of said Dr. Emerson, who then claimed to be their master and owner, intermarried and took each other for husband and wife. Eliza and Lizzie, named in the third count of the plaintiff's declaration, are the fruit of that marriage. Eliza is about 14 years old and was born on board the steamboat Gypsy, north of the north line of the state of Missouri and upon the river Mississippi. Lizzie is about 7 years old and was born in the state of Missouri at the military post called Jefferson Barracks. In the year 1838, said Dr. Emerson removed the plaintiff and said Harriet and their said daughter Eliza from said Fort Snelling to the state of Missouri, where they have ever since resided. Before the commencement of this suit, said Dr. Emerson sold and conveyed the plaintiff, said Harriet, Eliza, and Lizzie, to the defendant as slaves, and the defendant has ever since claimed to hold them, and each of them as slaves, at the times mentioned in the plaintiff's declaration. The defendant, claiming to be owner as aforesaid, laid his hands upon said plaintiff, Harriet, Eliza, and Lizzie, and imprisoned them, doing in this respect, however, no more than what he might lawfully do if they were of right his slaves at such times. Further proof may be given on the trial for either party. It is agreed that Dred Scott brought suit for his freedom in the Circuit Court of St. Louis County, that there was a verdict and judgment in his favor, that on a writ of error to the Supreme Court, the judgment below was reversed, and the same remanded to the Circuit Court, where it has been continued to await the decision of this case. In May 1854, the cause went before a jury, who found the following verdict, viz. As to the first issue joined in this case, we have the jury find the defendant not guilty, and, as to the issue secondly above joined, we have the jury find that before and at the time, when, etc. In the first count mentioned, the said Dred Scott was a Negro slave, the lawful property of the defendant, and, as to the issue thirdly above joined, we, the jury, find that before and at the time, when, etc. In the second and third counts mentioned, the said Harriet, wife of said Dred Scott, and Eliza and Lizzie, the daughters of the said Dred Scott, were Negro slaves, the lawful property of the defendant, whereupon the court gave judgment for the defendant. After an ineffectual motion for a new trial, the plaintiff filed the following bill of exceptions. On the trial of this cause by the jury, the plaintiff, to maintain the issues on his part, read to the jury the following agreed statement of facts. See agreement above. No further testimony was given to the jury by either party. Thereupon the plaintiff moved the court to give to the jury the following instruction, viz. That upon the facts agreed to by the parties, they ought to find for the plaintiff. The court refused to give such instruction to the jury, and the plaintiff, to such refusal, then and there duly accepted. The court then gave the following instruction to the jury, on motion of the defendant. The jury are instructed that upon the facts in this case, the law is with the defendant. The plaintiff accepted to this instruction. Upon these exceptions, the case came up to this court. It was argued at December term, 1855, and ordered to be re-argued at the present term. It was now argued by Mr. Blair and Mr. G.F. Curtis for the plaintiff in error, and by Mr. Geyer and Mr. Johnson for the defendant in error. Mr. Chief Justice Taney delivered the opinion of the court. This case has been twice argued. After the argument of the last term, differences of opinion were found to exist among the members of the court, and, as the questions in controversy are of the highest importance, and the court was at that time much pressed by the ordinary business of the term, it was deemed advisable to continue the case and direct a re-argument on some of the points, in order that we might have an opportunity of giving to the whole subject a more deliberate consideration. It has accordingly been again argued by counsel and considered by the court, and I now proceed to deliver its opinion. There are two leading questions presented by the record. Had the Circuit Court of the United States jurisdiction to hear and determine the case between these parties? And if it had jurisdiction, is the judgment it has given erroneous, or not? The plaintiff in error, who was also the plaintiff in the court below, was, with his wife and children, held as slaves by the defendant in the state of Missouri, and he brought this action in the Circuit Court of the United States for that district to assert the title of himself and his family to freedom.